Warning: the following video is a social studies-based lecture on Roe v. Wade. It is not meant to be an editorial statement. If you are seeking an advocacy video, then you will probably be unsatisfied. Please enjoy the learning experience, and please keep your comments civil.
Hey guys, welcome to HipHughes History. You see what I was doing there? I was walking the line. And on HipHughes History, we do that when we're dealing with controversial topics. And we're going to hit up abortion, reproductive rights, and Roe versus Wade in this quick mini lecture so you can wrap your head around it and really understand the governmental constitutional answers when you're discussing this topic, whether it's on a test or at a tea party. So whatever side of the issue you fall, we just want you to fall smart. And you can leave it down in the comments below. Just keep it sane and kind. Here we go, Roe versus Wade. All right, this is kind of a weird court case. Number one, because Norma McCorvey, who in 1969 got pregnant, she sought an abortion in the state of Texas, and the only exceptions were for rape and incest. So she was denied what she wanted, which was an abortion. And first, actually, she claimed she was raped, and then she couldn't prove that she was, and she dropped that claim. But she's denied that, and she actually gives birth to the child. So by the time that this court case goes to the district court and then to the Supreme Court, she's already had the kid. So in a sense, she doesn't really have a stake in this case. And that makes it strange right away. But it's Roe versus Wade, Wade being the Dallas district attorney, I believe, that argued this case at the district level first. So in the district court, Roe is arguing the constitutional argument that abortion should be a guaranteed right under the Constitution. And she uses her lawyers, a number of different amendments. And the district court sides with her. They use the First Amendment, that the abortion laws are really based on a religious belief. They use the Fourth Amendment, that there is a kind of a privacy in the Fourth Amendment that extends through the 14th Amendment. They use the Ninth Amendment. Ninth Amendment are undefined rights in the Constitution. And then, of course, I've already said the 14th Amendment, which makes this a federal case, that no state shall deny its citizens due process. And in a sense, they're arguing that these amendments combined create kind of a zone of privacy. And the state is arguing not so much that abortion should be illegal everywhere, but that this is a state matter and that there's no constitutional right to an abortion, so therefore it should be left up to the people to legislate in their state. That's what it comes down to. And at the district level, Roe is going to win, and that's why we have Roe versus Wade. Roe is in the winner status. Wade, who is the district attorney representing the state of Texas, is now going to argue this case at the Supreme Court. So bang, bang, let's go to Washington, D.C., and let's take a look at the Blackmun decision of Roe versus Wade, 1973. Here we go. All right, so we're going to break it down. I'd like to explain the decision, at least the rationale behind the decision, and then again, you're going to agree or disagree, and that's your prerogative, and we'll leave it down in the comments below. But actually, Jay Floyd, the guy who was arguing for the state of Texas, actually opened the proceedings with what's called the worst joke in legal history. And he said something, I'm going to get the quote wrong, but as it would please the court, whenever a gentleman is arguing against two beautiful ladies as such, they're always going to get the last word. Dead silence. I read that Berger, who was the Chief Justice, stared the Floyd guy down. He came down and whipped him with his robe. But here we go. Well, we're going to explain the decision. And even women's groups, pro-choice groups, have really come down a little bit on the rationale that Blackmun's going to put his money down. Because there's a lot of amendments and there's a lot of constitutional arguments that were being made in defense of a woman's right to have an abortion constitutionally. But basically what he comes down and saying is that really what we're interested in talking about is what's the compelling state interest? Like, why would the state want to regulate abortion? And the two factors would be, number one, that they have a compelling interest in women's health and making sure that they're safe. And number two, this other compelling interest of protecting the fetus. So what Blackmun does when he wrote the majority decision, and he was chosen because I believe that he represented the Mayo Clinic, and he actually had gone to the Mayo Clinic when he was writing the decision to do his own medical research. But the decision is very much kind of a medical decision rather than so much a constitutional decision. And what he basically says is that we can use a trimester rule to rationalize this right to an abortion. And he says in the decision that in the first trimester that abortion is safe. And because it's safe, there's no compelling interest to protect the women's health because it's safe. And the fetus isn't viable, so therefore there's no interest in protecting the fetus. And they go as far as kind of rejecting the argument of personhood for the fetus, so that's not even up for consideration in this ruling. But then he goes on to say that once you get to the second trimester, there is definitely an interest in regulating abortion for the health of the women in the second trimester. By the time we get to the third trimester, the Roe versus Wade decision says that the state has a legitimate interest in regulating abortion because of the viability issue. Now we're protecting the fetus because the fetus can survive outside the womb of the mother. But he also goes on to say that if you are going to ban abortion in the third trimester, there needs to be kind of a health clause for the woman. So this is kind of called the trimester rule of Roe versus Wade. And in the concurring decisions, they talk about the Fourth Amendment and the First Amendment, and especially the idea of privacy. Privacy is not in the Constitution. So this is kind of an interpretation of the Constitution, kind of an activist or broad interpretation of the Constitution that really uses the argument we see like in Griswold versus Connecticut. When the state of Connecticut had banned contraceptive, the court came in 1963 in Griswold and basically said that there's an expectation of privacy because of the Fourth Amendment and this selective incorporation idea of the 14th Amendment. And that idea extends to kind of create this zone of privacy. And that's really what Roe is putting its marbles in, this new zone of privacy that's now encompassing a woman's right to choose. The last part of the decision that really, I think, angered a lot of pro-choice groups is that Blackmun writes that this is not really a woman's rights decision. He writes that the most compelling argument for him is that this is a doctor rights decision. And the other side is basically saying that, look, this is a great idea, maybe, but it's not in the Constitution. And if we don't have it in the Constitution, then we can't rule. We have to let states make up their own mind. And now we're going to take a look at the cases that come after Roe, just so we can understand kind of more of the modern interpretations that have gone on in the last 30, 40 years since Roe versus Wade. There's only 4 of them. You can do 4 court cases. All right, 4 court decisions, all dealing with abortion after Roe versus Wade. We're going to just whittle them down really quickly. 1989, you have Webster versus Reproductive Health Services. This is the Rehnquist court, guys, that's basically going to say that a state doesn't have to pay for abortion services, that if they want to ban the funding of abortion services, that's not necessarily a religious First Amendment issue, that the people can express their will through that type of law, and that's constitutional. 1992 is a huge court case. This is Planned Parenthood versus Casey, and there was actually 2 different issues. One was dealing with spousal consent. Could the state of Pennsylvania make women get approval from the spouse, the husband, in order to get an abortion? And could you make minors get parent consent? And actually is a split decision where they uphold the child rule that they have to get consent, but that the women getting consent from the husband was knocked down. But actually Kennedy, one of the Supreme Court decisions, was originally thought to side with the more conservatives, and they thought they were going to flip Roe versus Wade in 92, but he was convinced to stay and uphold Roe versus Wade. But they actually got rid of the trimester rule in Planned Parenthood versus Casey. Now it comes down to the question, does the regulation in question place an undue burden on a woman's right to choose for an abortion? So basically what they said was, in the instance with the spousal consent, yeah, that can really get in the way. But in terms of the child, they're talking about more of a concern for the health of that child overriding her right to a legal abortion. Although there's a clause where you can get a judge and get permission anyway. Too much talk. Sternberg versus Carhart is 2000, and this was really an attempt to outlaw a procedure called partial birth abortion. And the law, the way that it was written pretty broadly and really leaving no room for the exception of the health clause for the woman, which Roe mandates. So actually the partial birth abortion was upheld because of the life of the mother not being a factor. But then Congress went to town. They wrote a law called the Partial Birth Abortion Ban Act in 2003 that's much more specific in really outlawing the second trimester procedure of partial birth abortion, and now that's the law of the land. But right now, we're still legal Roe versus Wade, and really the movement, at least from the pro-life side, has been a concentration more on over-regulating the standards and access to abortion clinics. So since I believe 2005, 2003, right around there, we've had hundreds of new state regulations on abortion clinics, such as zoning requirements, permits, health codes, and in fact, I believe Mississippi is set to become the first state in the nation since Roe versus Wade to not have one abortion clinic that's accessible to the citizens of Mississippi. But you might be good with that, maybe you're not, I don't know. I was just walking the line right there. But now you have the very basics on Roe versus Wade. You can leave it down in the comments below. I expect that you're gonna. All right, be kind to each other, guys, and remember, where attention goes, energy flows. We'll see you next time when we do some of the teaching on the YouTube. I'm gonna go walk the line out now.